Welcome to Canada's Missing and Murdered Aboriginal Women, Learning from the Missing Women Commission of Inquiry. My name is Avnish Nanda, and I'm one of the Osgoode Hall Law students who helped organize today's discussion. Before we begin, the event's organizers, which include Osgoode's Indigenous Students Association, the Distinguished Speakers Series of Osgoode Hall Law School, Osgoode's Women's Caucus, and Just Law, would like to thank certain individuals and organizations who made this all possible today. First, Dean Sawston, who's the Dean of Osgoode Hall Law School, and the Dean's Office for all their encouragement and support. Virginia Corner in the Office of External Relations and Communications here at Osgoode for her communications assistance. The Research Office here at Osgoode for providing the food outside. And Legal and Lit, which is the Student Council here at Osgoode, for their funding assistance and patience while we were figuring this event out. And finally, our remaining sponsors who can be found listed on our event poster. Without them, none of this would have been possible today. So let's give it to them.
Well, it's a great pleasure to see you all here today. I'm Benjamin Berger. I'm a professor here at Osgoode Hall Law School, and my role is very discreet. It's to introduce our moderator, who's going to be handling the balance of today's session. And we're very fortunate to have Brice Davis here moderating the session. Brice is, in my view and in the view of many in the community here, just one of our most outstanding criminal lawyers in Toronto. She holds a master's in criminology, her LLB from the University of Toronto, and she's a great friend of Osgoode Hall Law School. She's been a great support here in her teaching, and as well, I should say, in her scholarship. She's uniquely well placed to be moderating today's session because not only does she do this extraordinary work in her day-to-day practice, but she has been deeply involved in commissions of inquiry, including the Aurora Inquiry, a number of others, the Inquiry into Forensic Pathology in Ontario, and is currently counsel for Elizabeth Fry Societies in the inquest into the death of Ashley Smith. So, Brice, we're very grateful to have you here today. Thank you.
So largely my job is to sort of keep things on track, which is sort of the easy job today. But what I'm going to do first is introduce the two speakers. They're both going to do presentations for about 20 minutes, and then we'll take questions from all of you on the work that they've done. So without further ado, I'd like to introduce David Eby and Robyn Gervais. David is the Executive Director of the BC Civil Liberties Association and also an adjunct professor at UBC. His work focuses primarily on reforming public policy that impacts the poor, mentally ill, homeless, addicted, and otherwise marginalized people. The BCCLA was originally granted standing at the inquest, but withdrew, and since then he has authored an amazing report called The Blueprint for an Inquiry, critical of the work of the Opal Commission and laying out some lessons that we could all learn for inquiries going forward. In December, David's leaving his position at the BCCLA to enter provincial politics. He'll be running for the NDP in the provincial election this spring. Robyn is a graduate of UBC Law School and is currently practicing in Toronto. She transplanted about a month ago. She had the unique role in the inquiry of being the independent counsel for the Aboriginal interests. She was appointed in August of 2011, but they made the decision in March of 2012 to withdraw from the commission because of perceived biases and limits or failings of the commission. So I'm sure you both have a lot to offer in terms of how inquiries work and more specifically how they should work. David?
Thanks. I'm actually going to speak My name is David Eby. Thanks for having me. Thanks for the wonderful introductions. Thanks for all the students and the student groups that were involved in organizing this. I really appreciate the opportunity to come here and speak to a whole different group of people about what happened with the Missing Women Inquiry and what lessons can be learned so that it's not repeated. I came to Osgoode for second-year law school. It was a very different building at that point. I think it really spawned my interest in prisoners' rights, being in the building, the old building. It's much nicer now. I really like it, and you're very fortunate to have it, let me assure you. The missing women inquiry happened because of the people that are in the photo behind me. Every February 14th in Vancouver, women from the Downtown Eastside Women's Centre, from First Nations groups, Off Reserve, On Reserve, come together with their allies in the Downtown Eastside. Everybody gathers at Main and Hastings, and there's a memorial walk. And the walk goes to Crab Park, which is on the water, which was a very important site for a number of the women who were murdered, and a number of other sites where women were last seen, where they lived, to memorialize and to remember the women who were killed and who disappeared. It was because of these annual pilgrimages that the inquiry was called, because the clear demand of these marches from the beginning was that there be a public inquiry into, first of all, initially, why were the women going missing? And then when Picton was arrested, why did it take so long to arrest Picton? Why were the police not listening to the family members of women who went missing? And then into why were women continuing to go missing in BC along the Highway of Tears, Highway 16 in the north, northwest of British Columbia, Prince George, Prince Rupert area, and what could be done about it. And so finally, after years and years and years of these protests, the inquiry was called. So the context of this whole thing, the news clip gave you a bit of an idea. But those women who were in the clip there and the people who you saw at the park demonstrating had been doing this literally for decades, having these protests. And that's the context of this inquiry. It was called in response to community demands, and also the great irony, ultimately, of the inquest. Robyn's going to speak some more about this, so I'll just touch on it lightly. The terms of reference for the inquiry were set by the government without any consultation that we're aware of with the women who had been demanding the inquiry. It set up a very formalistic legal inquiry, and the results of that flowed from that were significant. And it's one of the key. Sorry about that. It's one of the key errors that was made at the very beginning, and that informs one of our key recommendations in the report that's available up here at the front, and also for free online, called Blueprint for an Inquiry, which is that you need to talk to the people that you're ostensibly holding the inquiry for, especially when you're working with marginalized populations. You need to do outreach to those groups and say, what is it that you want to get from this inquiry? What is it you're looking for? How can you best participate? How can we structure it so you can participate? And that was something that was not done, and Robyn will go into that in more detail. So the first concern that we had after the inquiry was called, and many of our allies and many of the women who had been calling for the inquiry had, was these terms of reference, which were very restrictive and set up a very legalistic process. But then our second concern was the appointment of the commissioner. So Wally Opal was appointed as the commissioner. He was a former Attorney General for the province of BC. He'd been Attorney General during some of the period of the investigation into Robert Picton, during the trial of Robert Picton, I want to draw attention to a special guest who just came in, is my mom, who drove me out here. I just finished parking. Thank you for parking. That's right. So Commissioner Opal was selected. The major issue wasn't just that he'd been Attorney General during some very critical points of the Picton investigation and trial, but that he'd actually been doing a public relations campaign then on behalf of the government to say, well, there wasn't really a need for a public inquiry because we wouldn't learn much from an inquiry. He was on CBC radio and he said, inquiries are very expensive, and I really don't know what we would learn from a public inquiry that we don't already know. And that was the guy that the government said, yes, we want him to come and run this inquiry. So obviously, many people, our organization included, had some concerns about those comments that he'd made in advance. He hired a gentleman named Art Bertlieb, who'd been the lead commission counsel for the Jacansky inquiry, as the gentleman in the middle there, and then John Boddy on the right to be the executive director of the inquiry. Position you don't often think about, but this is the person who essentially runs the administrative end. The interesting part about Mr. Body is that he's a former Vancouver police officer and had gone into private investigations in relation to financial crime after that. But of concern, again, to many of the women was that the actions of the Vancouver Police Department were to be investigated by this inquiry. And here, two of the major staff involved already had some apparent conflict in that they'd been involved somehow in either the governments or the police departments that had failed, in the opinion of the women, and who were the reason for the inquiry in the first place. So despite those concerns, everybody hung in there. And when I say everybody, I mean it. All of the groups, despite these concerns, were still committed to the process at this stage. The terms of reference, the conflicts of interest that they were concerned about. And 21 groups ultimately made application for standing at the inquiry, including the BC Civil Liberties Association, Amnesty International, Pivot Legal Society. We were a group of 3 organizations that applied together. And then there was a group of women's equality groups that applied as a group. There were 14 different women's groups that came together to apply for standing. And Commissioner Wally-Opal, I think, sensitive to some of the criticism that had been levied, made a very sweeping ruling saying that everybody who had asked for standing would get standing, would be able to participate in the inquiry. But not only that everybody that had asked for funding should get funding. And it's important to recognize what he said when he made that ruling. And he said, these groups are really critical to me performing my function as a commissioner and doing the job that the government's asked me to do. And the government said, well, that's all very well and fine, Wally, but we're not going to fund all of these groups that you've asked us to fund. We're only going to fund the families to have lawyers present at this hearing. And so 2 lawyers were funded for the families. The commission itself had 9 staff members altogether, 8 lawyers. And then the conglomeration of lawyers that you see on the left-hand side of the screen, some of the most talented lawyers in Canada, in my opinion, are lawyers who represented either the police or government interests at the inquiry. Most of them funded through some sort of public pot of money. Some of them funded through police officers pay a little bit of money each month off their paycheck into a pool of funds that then funds legal representation for them when they need it. So you can quickly see when the government made their decision not to fund what the courtroom was going to look like. We got 25 lawyers for police and government and 2 for the families. At this stage, there was some very great concern. Even more concern, I do all my own Photoshop. Even greater concern was that the commissioner had designated a special group that would have only limited standing. So our organization, Union of BC Indian Chiefs, West Coast LEAF is the Women's Legal Education and Action group, Amnesty International, all of the groups that could probably send a lawyer without funding were given limited standing, which meant that our groups could only ask questions of witnesses if we were given leave by the commissioner. We could only call witnesses if we were given leave by the commissioner. We couldn't do anything without being given leave by the commissioner. Now, all of the lawyers for the police and government interests had full standing, so they could cross-examine any witness they wanted, they could call any witness they wanted, they had full participation rights, and then other community groups that had no chance in hell of having their own lawyers were also given full standing to ask any question they wanted, and it resulted ultimately in this very weird situation where community workers, self-representing, were asking questions of Vancouver police officers on the stand and so on. It was a very bizarre outcome from this, but that limitation on the participation rights of groups was really the final straw for many, including our organization. I'm just going to grab some water here. So that was looking very bad. It was looking like it was going to be a one-sided disaster. And the commission was badly embarrassed by the decision of government not to fund anybody. And we were asked by media, well, how much money is it going to take? How much money do you want for lawyers for the community? And we were like, oh, maybe if we had $200,000, we could do really well. And that'll be an interesting figure to come back to later. And we thought we were being super ambitious. We're like, oh, $200,000 for 21 different groups outstanding in legal representation. But we'll come back to that later. So the government said legal representation is not required. And so the commission said, okay, we're in a panic. What are we going to do? We'll hive off some of our budget that we were going to use to investigate what happened to the women, and we'll use that to fund 2 legal positions that will represent the interests of the women, given that they don't have their own lawyers. And while they're having this discussion, simultaneously, all those groups that got standing are having a discussion, and they have made the decision to boycott. They said, we can barely provide the services to women that we're providing right now. There was the WISH drop-in center for sex workers, for example. We can barely do what we're doing right now. We can't review 1 million pages of documents. We can't prepare to cross-examine 50 witnesses. We're not legally trained. We can't go up against 20, 25 police and government lawyers. So we're bowing out. And our organizations, Amnesty, Pivot, BCCLA, all bowed out as well for very similar reasons, and to support and stand with those women who refused to participate. And so when that boycott decision came out, there was a huge amount of urgency to try to level the playing field a bit. And one of the lawyers we have here today, Robyn Gervais, and then another talented lawyer, Jason Brattle, stepped forward and said, okay, we'll represent, the voices of First Nations, Indigenous people, and voices of the downtown East Side community. And you can still see that even with the appointment of 2 lawyers to represent these interests, and they were very strange positions. So these lawyers were put in a very challenging position of not having clients. There were no, they could take instructions from people, but also there wasn't the same solicitor-client relationship that you would have because they were representing these interests rather than individuals or groups who could give them instructions. So it was a very unusual situation, and most importantly for us, it was set up, again, without consultation with the community about, okay, we're in this situation, the government's refused to fund, we have all these lawyers on one side, what should we do? All of a sudden there was an announcement that these positions were being created. After the appointment of the independent counsel, the head of the Missing Women Inquiry on the legal team went out and did another public relations round, did a number of interviews, announcing these positions, and then being asked, well, are you worried that all the women who called for this inquiry are now standing out front protesting it instead of participating in it? And the response that was given was not, this is a huge concern. This inquiry was set up for these women, and now they're protesting their own inquiry and they're refusing to participate. Instead it was, you know what, I think we're going to be okay. I think we're still going to be able to get the job done. And to me, this was where the paths really diverged in terms of the interests of the commission and the interests of the community, where instead of saying this is the worst thing that could have happened and we're just trying to get by with what we can, it was an active sales job to tell the public that this was, you know what, it was going to be okay. And then things started getting really ugly. The commission announced that they had hired volunteers from Peel Regional Police who had called them up and volunteered to say, hey, if you want a special police perspective on the documents that you have, we'd be willing to have a look at them and review them and write a special report for you on it. So the commission said, wow, free expert witnesses, absolutely. So they hired these Peel Regional Police. Unfortunately, at the exact same time that the Peel Police were supposed to be doing this investigation of the RCMP and the Vancouver police operations, the RCMP were investigating 3 separate Peel police officers for corruption. One police officer had in fact redirected, the RCMP was doing a massive international drug sting, and they were monitoring these drugs coming in from South America, and the drugs had landed at Pearson Airport, gone to the courier, and then disappeared, and the RCMP couldn't figure out what happened, but of course they had GPS and these fake drugs. And they followed the GPS signal and found the drugs in a boat in the garage of a Peel police officer. So this is the investigation that's going on at the same time. So we're talking about conflicts of interest. Here, the Peel police are investigating the RCMP while the RCMP are investigating the Peel police. At the very least, we felt that that was the appearance of a conflict. Interestingly, when the report started falling behind schedule, John Boddy, the former Vancouver police officer, was sent by the commission to help the Peel Police finish the report into the Vancouver Police Department. So we have conflicts on top of conflicts on top of conflicts, and the report ultimately was critical, but was met with a lot of indifference given how it was authored. This, this slide, again, I'll explain it because it is not obvious. The silhouette of the woman underneath the flashlight represents proposed witnesses, sex workers who were going to come forward and talk about the difficulty they had coming forward to police and give evidence to the inquiry. The gentleman on the right with the ball cap, with the black bar, represents a sexual predator identified by the police who may have been named in the massive volumes of documentary evidence that were provided. And the treatment between these two groups, I think, tells the whole story. So the Vancouver Police Department and the RCMP made an application to the Commission, and they said, look, there are a number of people who are identified in the documents as sexual predators. We want their names to be automatically protected. We want their identities to be protected, and we want any disclosure of documents involving them to go through a very rigorous process. And we need these special protections for these identified predators. I'll give you an example. A man, a volunteer for the Chinatown Community Policing Office, was stopped on the stroll in the industrial area of the downtown east side and the sort of east part of it. He was wearing his mother's nylons on his head to his forehead. He had a butcher knife and duct tape and handcuffs, a butcher knife and duct tape in the back seat of his car. And he was driving the stroll when he was stopped by police. So this is the kind of information that was in the documentary evidence that was protected from being disclosed during the inquest. Automatically, you had to make a special application to reveal who this person was and explain what the purpose was of revealing that person's name. In comparison, at the very beginning of the inquiry, there were no protections for women who were going to come forward and provide information and say, yes, I was a survival sex worker at that time. I had an addiction. I was just barely getting by. It was an awful time. Here are some of the awful things that happened to me, and here's my experience dealing with the police. There were no protections at all. And then the lawyer for the downtown east side interests, Jason Brattle, brought an application saying there should be some protections for these women. If they claim vulnerable witness status, all of these lawyers should have to argue why their names should be revealed, why their identities should be revealed. It should be assumed that they get to protect their identities. And the Commission said, well, instead of, we agree there should be some protections, but instead of automatic protection for these women should come and make an application and explain why they're vulnerable, and then we can argue about it, and then we can decide whether or not they get the special status. And so that means that 25 lawyers for the police and government got to stand up and say why they thought that witness X shouldn't get the protection, and yet it was these exact same lawyers who wanted automatic protection for sexual predators. And just to be clear, I work for a civil liberties organization, so I agree with the idea that people shouldn't be automatically named in terms of the documentary evidence. But I disagree strongly with the idea that at least similar protections shouldn't have been applied to the vulnerable women witnesses that were coming forward. In terms of once the inquiry hearings started going, it became pretty clear that actually the report had already in many ways been written. Vancouver Police had done an exhaustive review of their missing women investigation and preempted the Commission by doing their own report into what they had done wrong. And they largely blamed all of the failings on a single civilian employee who was working the phone for the missing women desk at that time. Very rude to people, didn't take reports, told people that she wasn't going to take them seriously and so on, and in many different ways. Lots of people felt that that was an unfair representation of what actually happened at the time, that it wasn't just one civilian employee. It was a whole culture within the Vancouver Police Department, within the RCMP, that needed to be examined. The reason why I say, though, that the report looked like it was already written was that the first witness that took up most of the inquiry's first week, a very limited amount of time, was the author of the report. So this is someone who had no involvement in the missing women investigations, no firsthand knowledge of anything, but had written the report for the VPD, and he was asked many questions about his report instead of going to the primary evidence. And unfortunately, they ran out of time to ask the witnesses who had actually been there at the time to come forward and provide evidence, and I'll talk a little bit about that. But there are three key examples about why I feel that the report was already written and that the Vancouver Police report was going to be the one adopted by the Commission. The first was Laurie Senner. It came out at the inquiry that this former Vancouver police officer had actually written a book about her experience on the Picton investigation. This book was not disclosed in the documentary evidence. It caught everybody off guard, except for apparently the lawyer for the families, because he Googled this witness, and there it said, coming out soon, there's a book being written by this person. And so the lawyers for the families got in a huge battle with the lawyers for the commission because they wanted the book disclosed. Can you imagine there's a whole book written by a police officer at the time of the investigation about how frustrated she was around the missing women investigation and all of its failures, and the commission actively arguing against lawyers for the family about disclosing that book. And the book, ultimately, portions of it were read into the record. The whole thing has never been formally released, although it was leaked to a reporter. The Hells Angels had a clubhouse across the street from the Picton farm. The doorman at Piggy's Palace was a Hells Angels guy. Was arrested for torturing people on film. Anthony Terazakis. He was a horrible person. Dave Picton, a Hells Angels affiliate, a Hells Angels associate. Counsel for the Downtown Eastside Interest wanted to ask, well, is it possible that women didn't come forward to police because they were scared about retaliation from the Hells Angels if they did come forward with information about the Picton farm, given all these connections between the Picton farm and the Hells Angels? And the commissioner stopped him and said, I wonder if the Department of Justice has an objection about this. And the lawyer for the Department of Justice federally stood up and said, well, I don't know where my friend's going with this. I don't have any submissions on this. And then sat down. And then the commissioner said, well, I don't want to go into this area. This isn't an inquiry into organized crime. I don't want to hear the question. Or I don't want to hear any answer, and I won't accept the question. And that was that. So anything that pointed in a direction other than the official Vancouver police report was shut down very early. The Center book, the Hells Angels question, and so on. And then when the counsel for the families brought forward a list of 20 witnesses that they wanted interviewed, you heard some mention of it in the news piece. Among them, a guy who worked on the Picton farm and went to the RCMP and said, I think there's something really bad happening on the farm 4 years before Picton was investigated, or before he was arrested. And provided all this information about women's clothing and bloody knives and all this kind of stuff. And his tip was dropped. It was never investigated beyond some initial conversations. And the lawyers for the family said, well, maybe we should hear from this guy about what information he provided to the police and why that information disappeared. He was never called as a witness. His name was Bill Hiscox. There he is. He did a lot of media during the inquiry saying, why aren't they calling me as a witness? It was a very strange decision. The lawyers for the families were treated very badly. Their application for those 20 witnesses, to have those witnesses heard and for further documentary evidence disclosure, was not decided in a traditional way. It was actually, they made the application. The commission, a senior commission lawyer, then leaked the commission's decision on the application to the National Post. The National Post reported that none of the witnesses would be called and none of the documents would be ordered disclosed. And then months later, the decision that said exactly that was released during the hearing. So it was a really unusual scenario where the court actually leaked its own decision. It's something that you just don't see in Canada. But it's really emblematic of how the family's lawyers were treated. And Robyn will talk about how her experience there anyway. This news came out shortly after the inquiry, about 6 months after the inquiry got underway. These are the salary claims of the lawyers working on the commission for the first 6 months of the hearing. This isn't a full year, this is just the first 6 months. And when we were pushing for an inquiry, people said to our organization, you know what's going to happen? You shouldn't push for an inquiry. They're going to waste so much money on lawyers, and then there'll be less money available for women. You shouldn't push for an inquiry. You should push for funding for drop-in centers for women. We said, no, it's really important that we address the systemic issues, because otherwise we're just throwing money away. Anyway, we should know strategically what is the most important thing to do. We should have the community tell us where should the money be directed. Well, if you look at the budget for the WISH drop-in center for sex workers, $320,000 for a whole year, and compare that to the salary of even a first-year call lawyer on the inquiry, $200,000 for 6 months. So that lawyer over the full year of the inquiry's run is going to earn in excess of the budget for the only drop-in center for sex workers in Vancouver. It really puts into perspective that argument, and it made me feel really stupid for arguing against it. The MATVAN funding was cut and then barely restored, $250,000. Peers Victoria, that's their bare bones budget. They're currently getting $72,000. This is a drop-in center for sex workers in Victoria. And then there was the weird, right? So the weird was Wally Opal, in a break in the inquiry, flew to Toronto to star in a movie about a serial killer in which he played a victim by a movie by a B, at best, C-level director from the States. He went to a concert at BC Place where after he left the concert, the Vancouver Integrated Gang Task Force took him aside and said, do you know who you were talking to in there? That person's a member of the Hells Angels. So then he had to email all of the members, all the participants in the inquiry to say, yeah, I had a conversation with a Hells Angels member at a concert at BC Place. And then there was an allegation of sexual harassment, multiple allegations of sexual harassment, coming out of the staff of the Missing Women Inquiry. The inquiry hired 2 lawyers, one to defend the inquiry and one to investigate the inquiry. None of the alleged victims would talk to the lawyer that was hired to investigate the commission, by the commission. So given this, I really think it was a tragedy. Given this tragedy of the failure of the Missing Women Inquiry, the boycott, the women picketing their own inquiry that they'd called for, that was set up to respond to their concerns, the gross amount of money paid to the lawyers who said that there was no money. Remember the $200,000? I thought maybe for 21 groups. So when you look at all those failures, we tried our hardest to come up with a list of recommendations around, well, what could be learned from the Missing Women Inquiry? If you're setting up a similar inquiry that deals with marginalized women, and there's a call for a national inquiry into the disappearance and murder of Aboriginal women across Canada, what lessons can we learn? And the first and the most important one was the consultation lesson. So much of this could have been avoided with consultation at the very beginning. The terms of reference issue, the issue with the commissioner's conflict of interest, the issue with the fact that the women were boycotting their own inquiry. They felt like a part of it, they wouldn't be boycotting it. They felt excluded, just as they'd been excluded from the police investigations of Picton. Witness protections being placed from the outset so that women feel comfortable coming forward. Ultimately, the inquiry heard from, one sex worker? Maybe two sex workers. There was a real gap in any testimony from survival sex workers, from Indigenous people, and so on. Witness protections can go a long way to ensuring the participation of groups and working with community groups that work with these individuals, who they trust, to help facilitate them attending and providing evidence in the way that they can. Really important. I talked about conflict of interest. Respect, basic respect, not leaking the decision that you're going to make on counsel's application to the media months ahead of making the actual decision. And compensation. We also had a federal inquiry into missing fish in British Columbia. The irony is profound. Maybe it's not ironic, but the tragedy of it is really because on the missing fish inquiry, all of the groups that wanted to participate had full legal funding to participate. They spent in excess of $20 million to investigate the missing fish from the coast of British Columbia, and it went on for in excess of a year. And in comparison, no legal representation, no funding for interveners in the missing women inquiry. And so that compensation issue is not just about how much lawyers get paid, but also who gets paid. That list of the 25 lawyers for the police and the 9 lawyers for the commission, or the 6 lawyers for the commission and the 9 staff, and the 2 lawyers for the family and the 2 independent counsel really tells that story. So I encourage you, I spent a lot of time on the problems, and largely because I think we probably all already know the solutions. It's intuitive to most people about when you're working with marginalized populations, the basic principles of involving those groups and decisions that affect them. And also, if you pay yourself for 6 months in excess of the annual budget of the drop-in center. I think it's intuitive. So I spent a lot of time on the problems, but if you're interested in our view on what the solutions are, on the BC Civil Liberties website, which is bccla.org, there is a link to reports, and it's called Blueprint for an Inquiry, and it's very detailed in terms of 40 some odd recommendations about what could have been done differently around this inquiry. So those are my remarks today. Thank you very much for having me again. I look forward to your questions.
I'd like to start by acknowledging the traditional territory of the Mississaugas of New Credit and the Haudenosaunee people, and give my gratitude for allowing us to learn and gather here today. And I'd like to say thank you to David for his presentation, and thank you to Osgoode for having me here today. My initial involvement with the Missing Women Inquiry began in January of 2011. I was initially counsel for the Gervais County Tribal Council, which is a tribal council in northern BC that consists of 8 First Nations, and 6 of those First Nations are located on the Highway of Tears on Highway 16, and the other 2 First Nations need to access the Highway of Tears in order to access any major services. They also had a member of the Takla First Nation, which is one of the First Nations in the tribal council, whose DNA was found on the Picton farm. So they had an interest in the inquiry, and the then tribal chief contacted me and asked me if I wanted to represent them at the inquiry. So we applied for standing, and were granted standing, and that was in, I guess it was March of 2011, when we all received the word about whether we would receive standing or not. When the funding decision was made by the government, Gervais County Tribal Council then pulled out, as all the other groups did, because they couldn't have legal representation at the table, and for many of the reasons that David already cited. And as David indicated, there was a posting that was posted for independent counsel, 1 for downtown Eastside interests, 1 to represent Aboriginal interests. I had been involved in the inquiry, and I think my junior lawyer naivety status thought that there was still some value in it, although now I'm not so sure. And I applied for the position as independent counsel to represent Aboriginal interests, and was appointed shortly after in August of 2011. Today I'd like to speak a little bit about 3 areas. There's a lot I could say about the inquiry. I was a part of it for, about a year and 3 months, so I have a lot of experience there. But I think I'd like to limit my comments to the terms of reference, and I know David touched on that a bit, but I'd like to expand a bit more and talk a bit more about the imbalance in the courtroom and just how that played out in terms of evidence and witnesses and counsel. And then touch briefly on an issue that I haven't heard talked about a lot, and I won't profess to be an expert on it because I'm certainly not, but that issue is the jurisdiction of a provincial inquiry to look into federal policing issues. So I'd like to begin with the terms of reference and just talk about the consultation aspect. I remember when the inquiry was first announced in September of 2010. I was listening to the CBC, it was in the morning, and the inquiry was announced on the radio, and then, like a few minutes later, I hear Grand Chief Stuart Phillip of the Union of BC Indian Chiefs come on and say, wait a minute, there was no consultation here. First Nations organizations have been talking about an inquiry for years and years. The march that David spoke about, the Union of BC Indian Chiefs was there every year, and there was no consultation with First Nations groups at all. And so right from the beginning, there was opposition from the Aboriginal community about there being a lack of consultation. And the terms of reference were set, and they were extremely narrow. And how this played out in the courtroom was that a lot of times a question would be put to a witness, and the commissioner would say, well, we can't hear that answer because it's outside of the terms of reference. And so even though the terms of reference were crafted in a way that I thought anyway, it was to inquire into the conduct of the police officers. I mean, really, that's a pretty broad, and it could be interpreted in many ways. It was oftentimes interpreted very narrowly. And the one thing that the terms of reference, in my view anyway, as counsel for Aboriginal interests didn't look at, which I thought was incredibly important, was to look at the issue of systemic racism, or bias, whatever you want to call it. All of these women were sex trade workers. They were all drug addicted, and many of them, disproportionately so, were Aboriginal women. And so the potential for bias was obviously very high, but the terms of reference did not look at that at all. In my research about other inquiries that had taken place that had looked at this, I came across the Caribou-Chilcotin inquiry, which was an inquiry that looked at Aboriginal policing issues in the Williams Lake area in northern BC. Well, I guess it's sort of east-north. And I would just like to read out one of the terms of reference because I thought it was really on point. And if this inquiry had had a term of reference like this, then it wouldn't have been able to ignore that issue of systemic racism. So the first term of reference in that inquiry was to inquire into alleged incidents of bias during any aspect of a police investigation into the death, on or off reserve, of a Native person of the Caribou-Chilcotin region, once it has been established that it was a Native person, and I think this is the very important part, whether or not that bias influenced the manner in which the death was investigated by the police or the priority given to the investigation by the police. And that was never canvassed in the Missing Women Inquiry. When I first was appointed as counsel, we received a witness list and it had Dr. Bruce Miller on it. And Dr. Bruce Miller, we were told, had authored a report that looked at the question of institutional bias. And as counsel for Aboriginal interests, I was hopeful about that. I thought at least there would be one witness that would look at that issue. But as the inquiry got going, it became apparent that Dr. Miller wasn't going to testify and that his report would never be put into evidence. And we were never given a reason why. I've never seen the report, and the issue was just sort of put to the side. And so I think for many Aboriginal people who had any hope, well, for me, had any hope at all in the inquiry, once I found out the report was not going to be put into evidence and he was not going to be called as a witness, it really became a question of how could you possibly get evidence about institutional bias or racism out of police officers who are taking the stand and defending their individual positions. So I really started to get disheartened at that point. And just also to expand on what David said about consultation, I think going forward, if there were to be a national inquiry into missing and murdered Aboriginal women, I think there would have to be consultation with political organizations, Aboriginal political organizations, Aboriginal communities, Aboriginal service providers. And I also don't think it should be like a unilateral one-way discussion in that, you get consultation and then you set the terms of reference and then you're kind of stuck with that. I think it needs to be an ongoing negotiation until all the parties are happy with the terms of reference. If there's anything that I learned from this inquiry, from walking through drum circle protests every day into the federal court, well, most days, in the beginning every day, and then, once a week as the inquiry went on, is that there has to be buy-in from the community. And there was no buy-in from the community on this for obvious reasons. And in order for there to be buy-in, I think there has to be participation, and that just didn't happen here. I'd now like to talk a little bit more about the imbalance in the room. And I know there's been a lot said about this topic already, but when I decided to withdraw, I did it because I felt confident that I could not do my job anymore. As I said in the beginning, there was the issue of the Dr. Bruce Miller report not being put into evidence. And then in the beginning, there was counsel, so there was me and counsel for the downtown East Side interest, Jason Grattle, and 2 lawyers for the family. The VPD had 2 lawyers in the room, and on some days it would just be 1. And then the RCMP had 3 to 4 lawyers, and some days it would be 2, maybe 3 lawyers. So although it was still imbalanced, it wasn't as imbalanced as 20 lawyers against the 4 or 5 other lawyers. But as the inquiry went on and individual police officers were called to testify, each police officer would then get their own counsel. And as David said, these are the top lawyers in Vancouver and eventually across the country that were called in to represent these police officers. So all of a sudden there were just a stack of lawyers in the room representing police interests, and it felt incredibly imbalanced in the room. I thought David's slide was perfect because it really did show how it was every day. And then the witnesses taking the stand, the time allotted to the witnesses was the same. I mean, we had Deputy Constable Lepard, who issued the report for the Vancouver Police Department that looked at the missing women inquiry. That's the report that David spoke about. He was on the stand for 13 days. So, you know, and then you had family members who were on the stand for 4 days. So there was just an incredible imbalance of witness time as well. Now, I did leave the inquiry in March, and hearings ran until June, so I'm not sure what happened after that. But during the time that I was there, that's what I saw. The other sort of issue that I saw with the inquiry in terms of evidence, and not that I have a lot of experience or any prior to this one with public inquiries, but my understanding is that when a witness takes the stand, it's the job of commission counsel to elicit the evidence from the witness and get all the facts out on the table to inquire into what it is you're there to inquire about. But in this commission, that was left up to each individual police officer's counsel. So the lawyer who was representing the interest of the police officer had the first crack at getting the evidence out. So often the evidence wouldn't be, you know, sort of a probative look at what had happened. It would have been either to defend the witness on some sort of document that they knew was going to come to light, or to paint the witness in a very, you know, favorable light, like they had, you know, done this work in the community, or they had worked with Aboriginal people, or they had done this or done that. But it wasn't a probative look into, it wasn't a probative inquiry. And so what would happen is that would have to come out in cross-examination, and then counsel would be shut down because there would be time limits on cross-examination. So I felt that was a major procedural flaw that rendered a lot of the probative value of the inquiry, I don't want to say useless, but it should have been commission counsel getting all the facts out on the table, not their lawyers guiding them. I'd also like to talk a little bit about the jurisdictional issue. Now, as I said, I'm not an expert on this, and it's a little bit difficult to speak after David because, unfortunately, he's canvassed a lot of the issues that I wanted to speak about, and he had such a nice PowerPoint to do it. But I think if there's anybody in this room who is planning to, or knows anybody who is pushing for a national inquiry into missing and murdered Aboriginal women, I think this issue of whether or not the province has jurisdiction to look into federal policing issues is a legal issue that should be canvassed. And I haven't heard a lot of it in the media, but I have heard government say, you know, we don't need a national inquiry on missing and murdered Aboriginal women because we just did the Picton inquiry and that just looked at that. And so they sort of use that as to say that it's been done already. But prior to my withdrawal, we looked a little bit into the issue and did one research memo, where we looked into whether or not the provincial has jurisdiction to recommend changes with respect to the policy and administration of a federal police force. And especially in BC, and I'm not sure about the other provinces, but I know in BC, the RCMP contract with the province to provide police services throughout the province and in municipalities, with the exception of Vancouver. So this affects Indigenous communities. Obviously, they are policed primarily by RCMP. And again, whenever there were questions, well, not every time, but sometimes, when there were times when there were questions put to witnesses about RCMP policy or administration, they were rejected by the commissioner because he would say, it's outside of my jurisdiction. And at times, we were reminded by counsel for RCMP that they were there on a voluntary basis and that they were there as a good faith measure. And this also became a problem when it came to disclosure because the commissioner didn't have the power to order disclosure from the RCMP because it was outside of his jurisdiction. And that was a huge battle that Canon Ward took on as well. And I don't know what the outcome was in the end, but I know that he was consistently fighting it while I was there. So when we did this research memo, what we found was that the province does not have the right to inquire into a federal institution, services, rules, policies, or procedures. But there is an exception under Section 92, Sub 14 of the Constitution, which is the Administration of Justice provision. And the cases say that a province can look at issues that reflect on policing matters that bear upon public confidence in the administration of justice, but it can't be a direct focus into the management or administration of a federal agency. So if we couldn't look at the management or administration of the RCMP, who the Picton Farm was on in RCMP jurisdiction, if we couldn't look into the management and administration of how they handled this investigation, then to me that it rendered it ineffective. And I think that this is an issue, and I think it's obviously an issue for this inquiry, but I think that it lends support to why there needs to be a national inquiry into missing and murdered Aboriginal women. And I think those are my comments for this afternoon. Thank you very much.
You answered no, emphatically. You didn't think that would happen. And I'm just wondering whether you still are of the view that you don't regret leaving.
No, I don't regret leaving. I still think that, for all the reasons that have been said here today, the terms of reference, the lack of consultation, the imbalance of witnesses and legal counsel in the courtroom, the not looking at systemic racism or bias, for all those reasons, I didn't feel that I could do my job, and nothing has changed since then. I still don't feel that I could have done my job adequately for all those reasons. So no, I don't regret my decision to withdraw.
This was the big part of the big sales job of the inquiry was that they kept saying, well, it hasn't been great so far, but it's going to get better. So keep hanging in there, keep waiting. This is why when Robyn left, I understood immediately why, because there comes a certain point where someone keeps making bad decisions over and over and over. They say, you know what, this probably isn't going to change unless there's some kind of structural change. And there was no hint that there's going to be a structural change. In fact, it seemed to be getting more and more insular rather than more and more consultative as the process went on. I don't know if that was your impression as well, but I felt like it was just, at the end, it was like three guys, Wally, Art, and John, who were running the show, when it should have been this huge community of people running it.
Mm-hmm. It was interesting because, near the end of my withdrawal, which people were kind of not critical of after, but I was beginning to get a bit of buy-in from some people in the Aboriginal community, a couple of the organizations, and a couple of witnesses that did testify after, which also tied into my withdrawal because I put a proposal together to Commission Council asking for a certain amount of hearing time for these witnesses and was turned down. And so, after everything, it had been such a battle right from the beginning, and to ask for 4 days of hearing time and then be turned down after it took me months to get these people to even talk to me, then I just thought, okay, this is it. There's just no possible way I can have any effect on this. So while I think you're right, the process wasn't changing, I think because of the fact that I was, kind of showing up there every day, and I was doing things like live tweeting evidence, and so I was getting starting to get a little bit of support and buy-in and trust, I think, from some of these witnesses that were involved. In the end, the process didn't allow for that to happen.
You both talked about the narrow terms of the inquiry. Assuming they had picked a commissioner that wasn't in conflict of interest, and commission counsel who weren't in conflict of interest, is there anything the commission could have done up front to challenge those terms of reference? Is that doable in a public inquiry?
It's interesting because the terms of reference were set, I keep saying they're so narrow, but we don't really say what they were. There's a fixed date that the commission was allowed to look at, and it wasn't allowed to go past that date. I'm trying to remember what it was. It was 1998. 1997 to 2002, but there were a whole bunch of women that had gone missing before that time period, and so it was even in the time period. But the commissioner was appointed, and then he did a little bit of work, and then he after the province made its decision not to fund anybody, he went back to the province and said, we need to change the terms of reference. We need to create a separate study commission. So that in BC, there are two kinds of inquiries. There's study commissions, which are, it's a much less structured process where it's a less formal process. And then there are hearing commissions, which are much more court-like process. So he said, I want to create a parallel study commission where people can just show up and tell me about their experiences and so on. And that will run parallel with the hearing commission. The province said, sure, we can do that. So he went and, of course, he hadn't asked anybody again. You know, he was just like, I think this would be a good idea. And it wasn't a good idea because he was keeping the hearing commission. So when he did that, they said, okay, well, if you provide evidence at the hearing commission, then your evidence will be deemed admissible for the purposes of the final report. If you provide your evidence in the study commission, which was being set up for community members, sex workers, First Nations, people on off reserve to come and participate, then unfortunately, because you're not subject to cross-examination, because it doesn't have the rigor of the hearing process, it'll be taken as information only, but we won't be deeming it to be credible for the purposes of the hearing commission. So the separate equal process that was set up for all the marginalized communities was one in which their evidence would not be taken seriously for the purposes of the final report. And so there were two big problems with it. One was the fact that the evidence was worth less if you participated in the community hearings. The second was that he could go and get changes to the terms of reference, but he didn't on the really important issues. And he demonstrated that he could get those changes.
And could he have gone to court to force the issue of funding? I mean, we saw in the Aurora inquiry, maybe we didn't see, but part of the Aurora inquiry process was that Commissioner O'Connor disagreed with the government in terms of their views on privacy issues and actually went to the federal court and sort of took them to court to make more information public. Could the commissioner have done something like that over the funding issues or over any of the other issues that you raised? Is that something that would have been available, you think?
It was something that we talked about, the funding issue, but we were looking at it from the point of view, could we as interveners go and compel the commissioner, or compel the government to fund according to the commissioner's recommendation? And we came to the conclusion that we'd be totally, we'd have trouble withstanding. Not because we've been refused funding, but just because if the commissioner wasn't going to be there with us, for us to provide evidence that it was necessary for the commissioner to complete the commissioner's mandate wasn't really our place. The commissioner had to go and do that. And instead of saying we're going to go to court, instead of the commissioner's lawyer saying we're going to go to court, the commissioner saying we're going to go to court, they were out there saying we've created this separate but equal inquiry and so now everything's okay. And so they were actually finding ways to, and also we've hired Robyn and Jason as independent counsel, so this problem has largely been solved. You don't need to worry about it. There's a really good textbook if you're doing academic work on this called The Law of Public Inquiries in Canada that talks about commission's independence. And one of the areas of commission's independence are funding recommendations, where and the author says if the government doesn't follow a commissioner's funding recommendations, it does so at its peril. And the reason is that if you ask a commissioner to do something, and they say, look, you've got to fund these people to participate, otherwise I don't know what's happening, then you're actually interfering with the independence of the commission. You're setting it up for failure. And if the commissioner did go to court, our argument was that the commissioner had an obligation to resign. He said that these groups were necessary, they weren't funded, and now, given that he couldn't complete his task, he should have resigned. He did.
I have a question about procedural issues. So you both spoke about problems with evidence, putting in evidence discovery, timing allocations and the power imbalance in that. And I was just wondering whether there's a legal framework similar to the rules of civil procedure that pertain to inquiries, and if so, how could that change to rectify some of the issues that you viewed during the inquiry?
There were certainly applications that were put forth during the inquiry to try and level out the imbalance, but just by virtue of the fact that, I mean, it was set up entirely different in that the Commission Council called the witnesses, right? So even though I, as independent counsel, had powers to propose a witness, there was no guarantee that that witness would be called. So it really, I guess it was unfair in that way.
Was it case that Commissioner Opal got to set the rules of procedure for his own inquiry.
Yes.
So at the beginning, there were rules that all counsel had to follow about motions and witnesses and all of that, and timing that he controlled.
Yes. And there were various practice directives that were issued throughout the commission as well. So we would sort of be, show up one day and then there'd be a practice directive issued. One of the major practice directives was a move away from individual witnesses to a panel format. And that was actually right before I left the inquiry. So instead of having individual police officers on the stand, they were going to group them together in 2 or 3 or 4. And it would be sort of like a discussion among the police officers about what happened, which for cross-examination is a disaster. And didn't really give the opportunity, again, to sort of probe the issues.
Thank you.
With an inquiry of this kind, where it seems like from the beginning, well, there's all of these conflicts and bias, is there any sort of judicial review process? Like, is there a next step that can be taken? And also, do you think it's even worth it for the resources and everything to go to that next step if it's available?
We had looked at judicial review of a couple things right at the beginning, but mostly at the decision of the government not to fund. There certainly was open to counsel for the families the chance to go to court to challenge the decision of the commissioner not to call a certain witness, or the fact that the commission had leaked the result of this application before it was formally decided. Certainly showed a major problem inside the commission. That this issue of the RCMP's obligation to cooperate, given that they provide contract policing in British Columbia, the extent of that obligation to cooperate was also subject to judicial review, could have been. At the end of the day, for our organization, having pulled out, one of the consequences of that is we no longer had standing in the inquiry, and therefore our standing on a judicial review application would be even more tenuous. But for the groups that remained, it was a live discussion, but they were so, like, counsel for the families, we were in touch with them regularly, we were in touch with Jason and Robyn regularly, supported their participation as best we could, because we felt they had an important role to play. But they were so overwhelmed by what was happening. There were literally more than 1 million pages of evidence. There were so many witnesses that could have been called and weren't, and just dealing with the responses of 25 different lawyers who are opposed to your interest meant that they just contemplating going to judicial review. It was more of a theoretical remedy than an actual remedy for them.
Robyn, you mentioned that you felt that as the inquiry went on, you got more community buy-in. Mm-hmm. So when you decided to remove yourself from the inquiry, what was the reaction of the communities that you were representing? I understand and I absolutely agree why you did it, but I was just wondering what their reaction was.
It was varied, actually. Some of the witnesses that I was working with, they were disappointed. I think they were looking forward to testifying and having me lead their evidence. I had been working with them pretty closely, and so I think they were disappointed. But as a whole, I would say the community was very supportive of the decision. And some of the family members too. I was there every day for 5 months, and so I did build somewhat of a relationship with the family members who were there every day. So I think they were kind of upset as well. But I think largely there was support.
I hope you don't mind this. I'm going to share my experience of watching you this time. So there was a live webcast of the proceedings of the commission, and Robyn was supposed to be making her speech resign on a certain day, and they refused to hear her. They said, "No, we won't hear you, Robyn. No, not today, no, nothing," because they knew what was coming. And then put her over to another day, and then Robyn made her speech about why she was resigning. It's a wonderful speech. I think it's available online. I encourage people to, if you can, to check it out. Very powerful. Then there was this remarkable situation where lawyers just took turns standing up and saying why, why Robyn had made a bad decision in leaving. all of these lawyers who were endorsing this process, this failed process, all of them, well, I mean, I'm not going to do any ad hominem here. So all of them endorsing this process, standing up and saying, you know, this was a bad decision, you shouldn't have done this, like some of the most powerful lawyers in BC. And it was just to watch it was like, oh my God, like this is the worst. The commission council is the president of the Law Society of British Columbia now. So for Robyn to stand up and say, you know, I'm not going to play in this inquiry anymore, and frankly, badly embarrass the commission, was a huge and a brave risk to take, and it shows the level of, you know, the challenge that she faced in her role. But then to have this braid of people, and then her private emails with commission counsel were read out into the record by some of the commission lawyers to demonstrate that clearly they were doing everything they could to accommodate her, and they didn't even understand why she was leaving. And it was so bizarre, it was so like, to be outside the inquiry, to know that there were Aboriginal women in the streets with picket signs blocking an intersection because this process was so foreign to what they wanted to have happen. And then when the person appointed to represent Aboriginal interests stands up and says, I couldn't get 4 days of hearings to call the witnesses that I wanted to call. And then to have all these lawyers stand up and say, I just don't understand why you're leaving. This is a real puzzle to us. It's very, you know, it's, and then the commissioner himself said, you know, this is going to be a problem for something about your career. He started giving, I remember when you first came into my office and I gave you career advice, and like all this super insulting garbage that came out of this. Anyway, I was just like, you know, I don't mind saying it. Robyn is you know, being discreet about it, I understand that, but I just thought it was so outrageous, this parade of people saying that this was a bad decision. So the community that supported Robyn was the community that mattered, quite frankly. So,
I think you're next.
Yes, kind of more of a specific question, because I remember there was a time when the female representative of the task force made her own allegations into sexual harassment in the force, and sort of leaked to the newspapers her own personal stories of what had happened when she went to try to push these officers to take further steps to investigate these tips and so on that she'd be getting. I was wondering what role, if any, she ended up playing, because it seems to me that she would be a police officer that wasn't just trying to cover herself, because she'd already taken a step sort of off the limb to do that. And I was wondering if she got called as a witness at any point, or what kind of effect that had to have on our CMP officer speak.
I know that at one point there was talk about having her called as a witness. She was never called as a witness when I was there, and I'm not sure if she was called after.
sorry, we're just deciding which sexual harassment.
Yeah.
She was the spokesperson for the RCMP.
Yeah, she was.
Captain Galliford, is that who you were referring to?
Yeah, I don't know.
Okay, yeah, we don't think she was called as a witness.
But interestingly, yeah, it was Captain Galliford who made those allegations and said that they were all watching porn at work instead of working on the inquiry, right? Or instead of working on the missing women case. And but simultaneously within the Vancouver Police Department, there were very similar issues being raised by Laurie Senner, who was a former Vancouver police officer who had written this book, and then her book was blocked as well. So these systemic issues of sexism within the police forces themselves were blocked from being fully examined.
Do you have a follow-up?
I was just going to ask if there's any, like, what the movement is of the community groups right now following this inquiry, if you know.
Well, I guess I know what I see in the papers, and I see there's a huge call from the Aboriginal community for a national inquiry into this thing. It continues.
There have been a number of submissions made to the UN and to other international bodies around the idea of them somehow supporting a national inquiry or a national body to look at that.
So this kind of dovetails with that, is that given the scandalous nature of this inquiry, and combined with a lot of these fuzzy issues of jurisdiction and of judicial review, what is your sense of the value of the public inquiry, knowing that it continues to operate, any public inquiry continues to operate in the specter of this coming out of this, where do you stand on the values of these, even if there was like a national?
I
guess particularly.
Okay. I mean, really, I think I would just repeat what I said earlier about there being buy-in from the community. I mean, I think the public inquiry is for the public. And if the public doesn't have confidence in it, then I'm not sure how effective it can be. You know, I know you can ask me, I'm not going to comment on the report, because the senior report, I really have no idea what's going to say. I know the evidence that went in until March of this year. I know that it didn't look at the issue of systemic racism. I know that was potentially a huge issue. It still potentially remains a huge issue. But as far as, you know, the effectiveness of the report, I don't know. Without public confidence in inquiry and with it being in the news for some scandal every second week, I'm just not sure how much public confidence there is.
Do you think we should lose confidence in the public inquiry system generally from what we see?
No, absolutely not. I mean, now I'm sort of fascinated by public inquiries, and so I've been listening, not really closely, but the Charbonneau inquiry. It's fascinating to me, the things that they're finding out. And even today, about the residential school, applying to the court for documentation, you know, and I see things like that happening, and I think, okay, good. Like, people are trying to get to the bottom of things.
They're incredibly powerful tools for shifting the behavior of public bodies. So even with all the massive failure of the missing women inquiry, the Vancouver Police Department knew that this inquiry was coming. They knew it. They saw it coming a long time ago. They wrote their own report. They put all these different programs into place around sex worker safety and women's safety, in particular in the downtown east side. They established a new policy in relation to sex workers to try to facilitate sex workers being able to report bad dates to the police more easily. So even before a single recommendation was written, it's shifted the behavior of the BPD. In the worst inquiry, like I have a hard time imagining a worse inquiry. So the worst case scenario, if we had it, it achieved these things. And when you look at the Jacansky inquiry in BC, this is the guy who was tasered at Vancouver Airport. Every single recommendation of that inquiry was implemented to the letter by the provincial government. When you look at the recommendations of the Frank Paul inquiry in comparison, almost none of the recommendations were implemented. And so the differences between those inquiries tends to be government motivation. But even Frank Paul as well shifted the behavior of the Vancouver Police Department as well. So I'm a believer, like Robyn is, in public inquiries. I wish we didn't have to use them as often. I wish the money could all go to WISH or to PACE or POOLS or the MAP-BAN or sobering centers, but it won't go there. Just honestly, the money will not go to those things, but it may go to a public inquiry. And so, and those public inquiries can shift behavior. So.
He actually asked the latter part of my question, and I don't want to ask you to speculate on what you think the findings of this report might be, but maybe just for general knowledge for the audience, if you could speak to the types of findings that might come out, and then elaborating on your last point there, David, about shifting behavior. I wonder if both of you could speak to anything that might come out of this inquiry that you think would be some sort of saving grace, or any impact that it's already had on the behavior of the VPD or RCMP.
Again, I have no idea what it's going to say. The evidence that I saw go in was largely around policing procedure and techniques. Issues like jurisdictional issues, like, for example, one woman was reported missing in Prince George, close to where her home Aboriginal community was. But she was residing in the downtown east side, and her file didn't get transferred from Prince George to the VPD for a year, right? So it looked at things like that. So I expect there will be recommendations about policing procedure and techniques. As far as the benefits, I guess the benefits that I see and saw are very much the on-the-ground benefits. I saw families of murdered and missing women in the courtroom every day, forming relationships and getting to know each other and having some support for each other. And I don't want to paint a overly rosy picture of that, because there stressful for them, and they had their difficulties as well. But from my view, I thought, okay, at least they're here supporting one another, and maybe it's a healing for them on some level. And then again, because the inquiry was in the news every second week or twice a day, I think this issue has got a lot of attention in the media, which is a good thing. And I don't know, I guess I see some healing for individual people that weren't family members also. Like some people who became a part of the process, and through being there and being around family members and just being a part of it, I think there was some healing to them. So those are the positive things that I saw. But on a huge, or like on a large systemic scale, I don't really know. I don't know that there was a ton of benefit.
My prediction is that the report will largely be a reproduction of the Vancouver Police Department report into these investigations. But the Commissioner has said repeatedly, to our organization in particular, because we released this, as well as LEAF and Pivot, the Commissioner said, don't just reserve judgment. I'm going to come up with some great recommendations. And what if we come up with great recommendations and you say, you've gutted our inquiry by being so critical of it and so on, then you're really doing your clients a disservice and so on. So one of the problems that this inquiry report is going to have is that let's say it's got 50 recommendations, 10 recommendations, and we read them, we sit down with our clients and we read them, and everybody's like, oh wow, nobody participated in this, but man, they nailed every recommendation. This is amazing. The problem is that the community is so disgusted by this inquiry that if they even read the report, if they even look at it, for anybody to get really excited about getting out there and demanding that the OPAL report recommendations be implemented is extremely unlikely. And one of the things that ensures implementation of recommendations is political will, and that comes from the people. And so, given that people are just appalled by what has happened, even if Commissioner Oval writes, this is another talking about tragedies, this is another tragedy of the inquiry, that even if he writes great recommendations, they're probably going to be by government, and at very little political cost, because the people in the community are working too hard on demanding another inquiry, which is a federal inquiry. And you may say that that's not a good strategy for them, but for a lot of people, they can't and won't have any healing about this until they have a meaningful inquiry, and that's more important. The process is as important for this community as anything else, because most people know what the recommendations are that need to be followed anyway. Sex workers need a place to go that's safe, they need a way to exit from sex work when they're ready to do that. They need help with addictions and mental health issues when you're talking about survival sex workers, and they need a criminal code system where they're not put in jail themselves if they come forward to report a bad date. And so I think that those kinds of issues need to be dealt with, and most people know what they are anyway. So that was a long answer.
So justice needs to be seen to be done.
That was a much shorter way of saying it. You should be a lawyer.
I think we have time for one more question. Yep.
In 2011, as a participant of the National Aboriginal Rights Group, focused on this issue. And part of the time we looked at the terms of reference, but the other part was on other legal remedies that could be possible. And people put forward a lot of suggestions: human rights, going to human rights litigation, charge litigation, for tort. And I'm just wondering if now, given sort of the failure of the inquiry, if that is something that certain groups or families are looking at in your work.
I'm not aware of anything that's happening legally.
I think a lot of people are watching to see what the language of the report is on this, because if you file a human rights complaint that alleges a systemic discrimination based on sex or on race, and the report comes out from this inquiry as flawed as it is, it said that there were no issues around either of those things. You've got a huge evidentiary burden to overcome at a human rights hearing, and you're probably looking almost certainly at a summary dismissal of your claim, because this has been heard in a very court-like process, determined by someone who's in a position very close to a judge about a res judicata issue. So that, I think a lot of people are watching that. There were some people who were speculating that the Council for the Families, in particular, was using the whole process as a discovery process for a civil litigation claim, where violation claim. And interestingly, the lead lawyer was the lawyer for the families, is Cameron Ward, and his name is on the lead case for charter damages, which is Ward versus City of Vancouver. That's him. And so he's well aware of the fact that you get damages for charter violations. And so that's certainly something that the police repeated over and over. Don't let Mr. Ward use this as a discovery for a civil process for his clients, blah, blah, blah. But that's something that's very live too, I think.
I think we are out of